read a verse that when bad leaders rule, badness increases in a country. And when good leaders rule, goodness increases in a country. Finally, what is the maximum number of companies can an individual participate in under the law? I thank you, Mr. Speaker.
Honorable Mutuse, you may now proceed to respond. You have exactly 10 minutes to do that.
Thank you, Mr. Speaker and honorable senators, for this opportunity. I have, from the questions that have come across, there are many that relate to the companies, and with your indulgence, allow me to start from there. Senator Cheriot, Senator from Marakwet, and several senators have asked why I listed 21 companies and why I said I did not have an interest in some of them. Number one, I think it is important for us to understand the context within which we are operating. I am not an investigator. And the law under Article 94, Article 95, does not make a member of Parliament, the National Assembly or Senate, an investigator. What I'm required to do is to establish a prima facie case, to establish that what is happening is outside the requirements of the law. And having been in this country and with a lot of enthusiasm in matters governance, I also know that this Senate has had opportunity to consider the impeachment of the late Gachagua. And in that impeachment, because this is a house of record, you will realize that most of the companies that I've listed were also complained about by the County Assembly of Nyeri during the impeachment of Governor Gachagua. And the complaint was specifically that there was a brother to the late governor, and the brother is one Rigathi Gachagua, who was doing all the business in Nyeri County. And from that basis, therefore, I needed to expound to find out what these companies that had been complained about during that impeachment, what these companies that had been complained about in the Esther Minor decision in terms of money laundering had to do with the Deputy President and the things that I'm alleging against him. And it is on that basis that I listed these companies. I want to invite members of this Senate to also know that in doing this, it is not just about the direct evidence. It is also about the circumstantial evidence. It's also about the circumstances that led to where we are. That there are companies that were complained about doing business in Nyeri County. It came to this Senate. That the same companies were complained about doing money laundering, and a decision of the High Court by Justice Maina has been tabled before you. And today, we are complaining that the same companies are helping to do corruption and money laundering. And that's the reason why we bring those companies. Please notice that in an impeachment, because I've been asked about threshold, and I know you know about it, my work here is not to prove criminal liability. It is not to prove beyond reasonable doubt. My work here is not to prove civil liability, but to show political responsibility. And I have been able to do that. In terms of Vipingo Ridge, the question I want to invite honorable senators, and I request that you listen to me. I was told yesterday that Vipingo Ridge, the two sons of His Excellency the Deputy President, are mere directors, and that the shares are owned by the estate of the late Derito Gachagua. But then you ask yourself, all of you here, you have children, why would my brother's children own my estate and not my children? Why would my brother's children be the ones who are directors in my estate and not my own children? If you die today, will your children be the ones being directors of your properties, or it is the children of your brothers? Don't you see this is suspicious? It is obviously suspicious. Number two, in law, and I want to challenge anyone. An estate, what is an estate? An estate is the totality of your belongings. So, can an estate own an estate? It is administrators. We would have expected that the executors in the estate who are named in the will are the ones who would have been named in the shareholding. And we know all these trick games that are being played around to hide ownership. And that, because I talked about circumstantial evidence, that is to be compared with the affidavit of Mr. Jomo in terms of how Jomo was approached to be proxy in buying the property, and how Jahenda, the question that has been asked, is the one operating the accounts. And we have been able to show that the same Jahenda, the same lady who works at the DP's office, is the same person who is the manager at the hotel and is the one who is operating the accounts. So I invite you to see the web of secrecy, the web of conspiracy. It is a web. And this is why I said these are white-collar crimes. They are done by intelligent people. Sometimes it becomes very difficult to get direct evidence, but in the totality of the circumstances, it points to money laundering and corruption. Let me now go to Senator for Nandi, my good friend, Senator Cherangei. Thank you very much for the Bible verse. I'll keep on reading it, and every time I read it, I'll remember you. 5.2 billion wealth. Did I ask for the wealth declaration? I have said here I was not in an investigation journey. I was doing my role under the law to establish a prima facie case. And the last I know, in terms of public declaration, because this has also been asked, the Deputy President, during the presidential debate, as a candidate for election, did declare that it was worth 800 million shillings. I have listed companies, I have listed suspicious transactions that lead me to the conclusion that it is now worth 5.2 billion shillings. The law on unexplained assets, because this is important, the law on unexplained assets is such that you are asked, you own this, please tell us how you acquired it. Because as far as we know, your legitimate income cannot support this. That is what I have done. I have listed properties that I have laid evidence that they are either directly or indirectly owned by the Deputy President. It is upon him, and this law is established, it is upon him to tell us where he got money to buy those properties, because in as far as we know, his legitimate sources of income do not support that income. Senator Kinyua, thank you for the question. Treetop Hotel is owned by KWS and therefore is a public institution. The expectation at law is that it should be, if it was to be leased, that needed to follow the Public Procurement and Disposal Act, and therefore would have expected an advertisement, a competitive process, to leading to its acquisition and leasing to a private person. There is no evidence that that was done, and that's why I allege and I approved that the Deputy President used his office to influence the acquiring of Treetops Hotel, abuse of office. Whether we have had opportunity to discuss with the children and the widows of the late Nerito Gachagua, please allow me not to comment on that, because there are requests also, as I said yesterday, that we keep certain matters that come to our knowledge during this process in secrecy. Senator for Samburu, the necessity of including the companies, I have said. The children of the children of Rigathi Gachagua, they are in, I think one is in his early 30s, the other one is in his late 20s. Whether there is an age limit for somebody to obtain a loan of 700 million, no, there isn't an age limit, but the guess, yours and mine, how many children of that age in the Republic of Kenya would have security enough to secure a loan of 600 million? Because to secure a loan of 600 million, the bankers tell us that you have to place property probably that is 10 times more in value than that. When did they acquire that property? Number two, it is not our evidence, and this is important for me to clarify, that Abadea's Safari Lodges was acquired through a loan. it is an explanation that we have discounted. He said that they obtained a loan of 600 million, but the only document that was produced is an offer letter for the loan. There is no evidence to show that the loan was granted. There is no evidence to show any charge on that loan. And therefore, it is our contention that that explanation is not conclusive. That explanation cannot suffice. And therefore, it goes back to the Deputy President to tell us where he got the 535 million, where he got the 143 million to buy those properties, because the loan is not substantiated. Senator, in terms of Olive Gardens, we have been able to show Julian Jahenda, the one managing the hotel, and the one working in the DP's office is one and the same person. Jomo, we bought the hotel on a promise that the Deputy President, the truth of the matter is that
Conclude, Honorable Mutuse.
Jomo bought the hotel
2 minutes to
as a proxy for the Deputy President. What problem do we have with refurbishment at the office of the Deputy President? We do not have a problem with the tender, we have a problem with the priorities. Kenyans today, and the Deputy President is talking about it, are crying about services. Is it a priority to renovate the office, or is it a priority to give water to the people of Kibwezi? Vipingo Beach, I have explained whether you would bequeath your wealth to your children or to the children of your brother. Senator of Meru, the property, there is an admission from the response by the DP that he actually owns a property in Meru, so I do not need to belabor that point. He has already admitted he owns a property in Meru, but he says he got a loan from one of the local circles. He has not produced evidence for that loan. And therefore, to my contention, that issue is already proved. In terms of the NIS address in Mombasa and why we complain about it, imagine, and I do not want to imagine that, somebody was a member of Al-Shabaab, and the Deputy President, none other than the Deputy President, stood up and said our intelligence system has collapsed. Wouldn't that be the right time to strike? That is the risk that the country faced by that particular announcement. I thank you, Mr. Speaker.
Thank you. Let us have the second witness. As the counsel for the DP responds or clarifies on the issues raised towards them, may we have the second witness available for purposes of clarifications. Counsel, you may proceed.
Thank you very much, Honorable Speaker. Let me begin with the tortured question of the estate of the late Nderito Gachagua. It is, I think, a shame that will stick on Honorable Mutuse for the rest of his years on earth.
Counsel for the Deputy President.
Yes.
There are very few clarifications that were directed towards you.
Yes.
So I'll give you 5 minutes. You're not responding to the clarifications by Mutuse. You're responding to the clarification as sought.
Those are the ones I am. Honorable Speaker, there are quite a number of clarifications, especially on this estate issue, which please allow me 10 minutes.
All right, 10 minutes.
Thank you very much, Senate. Now, I began my cross-examination of Honorable Mutuse yesterday with asking him how long he has practiced law and what law he has practiced. The problems you have as a Senate, as a quasi-judicial body, are born out of inexperience of legal practice. If you had practiced any succession law, I'm answering the question.
Order, Honorable Senators.
I'm answering the question.
I'm sorry, Senator Kavindu, just have a seat. I couldn't take that.
Yes.
What is the source of this?
I asked him yesterday. He answered the question.
Yes, Counsel for DP. What exactly did you say?
I just wanted to say that the National Assembly was provided with an affidavit by the executors of the will of the late Nderitu Gachagua. It is before you. It is volume number 4, stated, called the Further Affidavit of Nderitu Gachagua, Rigathi Gachagua. It should be before you. In that affidavit, the two executors state in comprehensive detail everything concerning that particular estate. They are as follows. 1, the estate property was divided in accordance with the will. The probate matter commenced and went all the way to the end to conclusion. All issues were resolved within the court case and in a sense are now res judicata. That is issue number 1. Issue number 2, you will find in that affidavit between pages 11 and pages 19.
Who sought that clarification?
I was asked, the question was asked here, I think, by Senator Dulo asked.
For DP, do not respond to what Honorable Mutuse said.
Senator
Pick
Dulo.
a senator's issue and respond to it.
That's what I'm responding to.
Exactly. So whose clarification are you?
Senator Dulo asked, can you please address the question of disinheriting the widows, if Hunter could confirm that? I believe she did. That's what I'm answering, yes. And so the will, as I'm explaining, does not disinherit the children or the widows or anybody else. It is merely because in the motion brought before you, there were properties listed in the motion that were part of the estate. That is the only reason this estate has become the subject of proceedings before the Senate and the National Assembly. So when you look at the will, as I've said, between pages 11 and 12, at page 13, if you have the document before you, this is volume number 4, there is a long list of how this estate was divided. And I won't go through it, you'll be able to read it yourself. That's number 1. Number 2, you will see an affidavit by the executors, except the Deputy President who did not sign this affidavit. These are the 2 remaining executors who have signed it, explaining between pages 4 and page 9 everything that was done in accordance with the law and in accordance with the law of succession, and that no one's property was taken away.
Senator Dulo, you know our rules. Proceed, Counsel. Proceed.
Yes. Now, I've been asked some questions about the issue of the Moranga video and about the shareholder agreements and whether 2 wrongs make a right. Our position is the opposite. Our position was that the address by the President in Moranga was in fact in confirmation of the agreements. The President was merely saying that they are implementing the agreements they agreed upon, and it was incumbent upon his deputy to assist his President in confirming that they were implementing the agreements. That is the purpose of the video. That is the purpose of those agreements. It is not to say kufa makanga, kufa dereva. I think Senator Beth asked that question. It is to say okoeni makanga na muokoe dereva. That is what we're asking you to do this morning. Senator, I believe Eddie, Senator Eddie Owiti, my good friend, has asked about the interrelation between Articles 91 and Article 232 and how those interact with the agreements. If I would call your attention, honorable senators, to the contracts themselves again, I don't know whether you have them. The contracts are in volume 3, and I'm referring you to page 429. At page 429, this is what the agreement said, and I'm reading, this is the primary agreement that was signed between UDA and between Fort Kenya and ANC. This is what it said. Further terms, parameters, and details of the sharing of positions of responsibility in the national government pursuant to this article shall be contained in a separate schedule to this agreement, which schedule shall be negotiated and executed before the date of the general election scheduled on 9th August. So there were subsequent agreements executed on how these shares were to be divided and to be implemented. That is issue number 1. But issue number 2, the parties gave themselves some room, and you'll see this at page 430. This is Article 22, subarticle G. Notwithstanding the content of this article, the founding member parties hereby commit to make any adjustments that may be necessary to accommodate the development priorities of other parts of the country to ensure equitable distribution of Kenya's national resources and wealth for the benefit of every citizen and every part of Kenya. When the Deputy President takes a stand, we will be demonstrating to you with videos where both he and his boss, the President, went out of their way to say that the voting did not matter to how they were going to implement the development agenda. I think I was asked whether there are any contracts or agreements that were signed on behalf of Mount Kenya. I did not see any. We don't have any thus far. There were several parties from Mount Kenya, but they did not negotiate anything. Then an important question. The Deputy President did not say the government is a company. When you read the statements, he was making an example. It's like a company. It was a tool to explain a document. That's all he was doing. I'm pressed for time here. Yes, Senator Chariot asked a question about two wrongs making a right, and whether the current DP is conceding that because he did what the former DP did, that then he's guilty. Again, far from the truth. We are asserting, when you read the documents, the documents at page 412, this is the article where the President spoke, the former Deputy President spoke in Moyale. This is what he said. The Deputy President reiterated that he used to ask tough questions when attending the National Security Council meeting about schemes of murder. It is something that has troubled me a lot, and that is why we have put it to the Kenya Kwanza Manifesto that extrajudicial killing must come to an end. It is illegal and constitutional and offends every principle of the right of life. In law, there is no secrecy where crimes are committed or there is violation of the Constitution. The Deputy President was merely following the mentorship of the man who occupied the office before him, and was not releasing any secrets that did not concern illegalities or unconstitutionality. So that deals with the question of oath of secrecy. I think that was asked. And because of shortage of time, I'll allow my learned colleague, Mr. Elisha Ngoya, to come and answer a few questions. Thank you very much, Honorable Senators, for your time and your attention.
How many minutes, Clerk?
Mr. Speaker, 3 minutes will be enough for me.
No, we need to know how much time you have. Okay. You have 2 minutes.
Okay. Thank you, Mr. Speaker. Ongoya for the Deputy President.
Proceed, Council.
Thank you.
Council.
To the question whether the Deputy President is aware that county governments are distinct, our answer is simple. Governments at national and county levels are distinct and interdependent. So the constitutional architecture is not to create pigeonholes, is to create cooperative and interdependent governments. And just to bolster that argument, you will notice that the allegation against the Deputy President on Nairobi River relocation is not that he destabilized Nairobi County government, is that he refused to support implementation of a resolution of cabinet, a national government institution. Meaning even at that level, that was the understanding that this was an intergovernmental approach to clean up Nairobi River. On the question of Julian Jahenda, allow me to say this. The person who has brought Julian Jahenda in these proceedings is a deponent of an affidavit. Allow us to hold him to account on that affidavit when he comes to testify himself, because we have questions for him around this witness too. Then finally, on the question of Treetops Hotel, let this be very clear distinction. Treetops Hotel was not acquired by the company in question from KWS. Treetops Hotel was an assignment of lease. When the Kenya government gives you a lease, say 99 years, you can sell that lease. So it was an assignment of lease that was already assigned by KWS to a third party. So the construction that a company associated with the Deputy President, rightly or wrongly, got this property from KWS is actually wrong. There was a completely different private property that had a lease. Then that company holding that lease assigned that list. Thank you so much. My 2 minutes are over.
The second witness. Order, honorable senators. Senator Olekina, proceed.
Thank you, Mr. Speaker. Mr. Speaker, my question to Mr. Mula. Mr. Mula, if you look at the response in volume 6 by the Deputy President, the Deputy President says as follows, 4.2, volume 6, which is in page 11, in response to the allegations that you called him, or he called you, to be able to push for the bid board. He said that this is clear in paragraph 4 of the witness affidavit of Andrew Mula. He contradicts himself by claiming that on the 11th July 2023, I pressured him to surrender the original bid board, yet by the letter dated 5th of May 2023, KEMSA had requested for collections of the original bid. Thus, there was no cause for pressure to be exerted on Mr. Mula or any other person. Now, in your affidavit on page 70, you put an excerpt of your WhatsApp or communication between yourself and Dr. Rigathi, where Dr. Rigathi, it's alleged, he said, Dr. Ikunu Rigathi here, kindly contact me. When possible, there is a document for HE we are trying to collect. In the same affidavit, you have annexed 3 letters. One letter dated June 30th, and I want you to keep in mind of the 30th of May. June 30th, which is a letter sent to you, from KEMSA to EACC, requesting for the bid board. That is June 30th. That is a month after the date that the Deputy President alleges to have received information from KEMSA asking him to collect the bid bond. Secondly, you have a letter dated 11th July, where you communicate to the company called Shabika Impex Private Limited, asking them to collect the bid board. Yesterday, when you were being cross-examined, you said that you were afraid, you felt pressured when the Deputy President called you, allegedly, and asked you to surrender the bid board. Could you please give us a chronological of events? Because this letter is dated 11th that you sent to them. You allege that the Deputy President called you on 11th.
Honorable SC, Rule 23 of the Rules of Procedure. SC Okenyuri, he's gotten the question. He's gotten the question.
Thank you, Mr. Speaker. I also wish to ask Dr. Andrew Mula the following. Confirm if the Deputy President did call you. 2, kindly confirm if Shobika Implex Private Limited, whose agent in Kenya is Crystal Kenya Limited, had emerged as one of the winner of the 3.7 billion mosquito tender before the tender. And finally, what was the issue with the bid bond that you said yesterday you were trying to go pick from EACC? Thank you.
Senator Kavindu.
Thank you, Chair. Mr. Speaker, my question is directed to to Mutuse and maybe his lawyers. Yes, I'm directing it to his lawyers. Please, kindly give me my time. I didn't talk, Olekina, when you were talking.
Senator Kavindu.
Thank you, Mr. Speaker. Let me go
Only
ahead.
address yourself to the chair.
Thank you.
Proceed.
One of my questions is about the speech which Honorable Mutuse said that the Deputy President addressed from Mombasa. My question is there any law preventing either the President or the Deputy President from intervening if they see any failures with the National Intelligence Services? Is there any law preventing them from intervening or questioning the National Intelligence Service, or is there any law directing them where they should ask these questions from? Two, the lady, Honorable Justice Esther Maina, has she ever made any complaint after the case was done? Thank you, Mr. Speaker.
Senator Bone.
Thank you, Mr. Speaker. Mr. Speaker, to Dr. Mula. Dr. Mula, I can attest that the number you have put here, through which His Excellency the President pressured you, he relates very well with me because in the days we used to talk with him, I used to use the same number. Your evidence is so critical that we would like you to walk us through that conversation between the Deputy President and yourself, during which time he was putting pressure on you. Mr. Speaker, sir, Tom Masharia, Counsel, you are a man of many years of experience, and you know the hierarchy of laws. The Constitution is at the apex, and all other laws are subservient. In your attempt to justify, or rather to protect, and secure the Deputy President from the accusation that he breached the Constitution, Article 27, which prohibits him from discrimination, you have chosen to justify it by using an act of parliament called the Political Parties Act that provides for the agreement. Tell me, are you telling me that by dint of that act, which is subservient to the Constitution, which the Deputy President violated, therefore the act sets him free? And finally, my younger brother, Ongoya, you have told us that for Mutuse to be able to prove that there was insubordination, he needed to bring something from the supervisor.
Senator Hamida.
Thank you, Mr. Speaker. I remember I am the one who raised this motion, this statement on the mosquito net for investigation. So I am so much aware of this investigation that went on. But Dr. Mula, apart from the financial loss that KEMSA incurred, did the alleged interference of the relationship, the alleged interference affect the relationship between the Global Fund and KEMSA? Because I remember, of course, the tender was terminated, which was about 3.7 billion. Global Fund terminated the tender. So was there any a relationship lost between the two? Number two, did the PS Josephine Mburu and CEO Terry Ramadhan lose their jobs due to this tender process, during the tendering process of the mosquito net tender? Number 3, did you feel intimidated and coerced to act given the office of the DP? Thank you.
Senator Wafula.
Asante Mheshimiwa Spika. Daktari Mula, madai kwamba ulipata simu kutoka kwa naibu rais kufuatilia jambo linalohusu mwanawe. Wewe kama mtumishi wa umma, unapopata simu kutoka kwa kiongozi wako wa kitaifa akifuata yale yanayohusu mwanawe, unaona ni vema kutekeleza jinsi anavyotaka ama kufuata katiba ili kutetea yeyote aliyeomba nafasi ya kufanya kazi? Asante sana Mheshimiwa Spika.
Senator Munyihaji.
Pia mimi swali langu ni kwa Daktari Mulwa kwamba hii zabuni ulisema kuwa ilifutiliwa mbali. Je, wakati ilipofutiliwa mbali kuna hasara yoyote ilitokea kwa serikali ama kwa KEMSA kutokana na kufutiliwa mbali kwa zabuni hiyo? Pili ni kuwa wewe kama mkurugenzi wa KEMSA ulichukua hatua gani ulipopata simu ama ulipopata maelezo kutoka kwa naibu wa rais kwamba hiyo tenda ama hiyo zabuni ipewe mtu fulani? Asante.
Senator Muma.
Thank you, Honorable Speaker. Dr. Mulu, I have 2 related questions to you. One, is the return of bid boards part of the procurement process? And if it is part of the procurement process, would you say that a call from the Deputy, His Excellency Deputy President, on this issue amounts to interfering with the procurement process? Thank you.
Senator Mariam.
Thank you, Mr. Speaker, for giving me this opportunity. My question is to Dr. Mulwa, that you said DP calls you. Is there, when he calls you, is there any interference with the procurement process? Thank you.
Witness, you may now proceed to make the clarifications as sought by the honorable senators. You have 10 minutes to do that.
Thank you very much, Mr. Speaker, sir, and honorable senators. I will try to answer the questions that have been put forth on the matter of the procurement of the long-lasting mosquito nets by the various senators. Mr. Speaker, sir, the Senator for Narok asked me to give a chronology of what happened so that I may be able to bring out the issue of the pressure that I got from His Excellency the Deputy President and alluded to the letters that I have submitted in regard to the tenders. Indeed, Mr. Speaker, sir, on around the end of April, the Global Fund wrote to the Kenya Global Fund Management Office, communicating a pre-award review decision to terminate the procurement of the 3.7 billion mosquito net tenders. Mr. Speaker, sir, this was after the procurement had been done earlier on in February by KEMSA, and it's a usual procedure during the procurement under the Global Fund. After the evaluation of the tenders, the evaluation report is shared with the Global Fund to authenticate if full procurement procedures and law have been followed. On review, the Global Fund realized that the tender, which the evaluation committee had recommended to be awarded to one Shobika Impex Limited, had an issue. And Mr. Speaker, I will refer to the bid bond, which I shared in the documents. In the motion, I think it's page is page 76 out of 85. Mr. Speaker and honorable senators, if you look at the bid bond that I'm referring to, the bid bond down there has a stamp of the 21st of February 2023, having been received by one Monica at 9:37 a.m. Mr. Speaker, sir, this tender was running at the time this bid bond is being received. The tender was supposed to close on the 10th of March, but the earlier closure, this bid bond, did not come as part of the tender document. Usually, bid bonds are annexures to the tender document, and therefore, this bid bond came as an ordinary mail. Further, if you look on top of that page, it's written PD, which is Procurement Department, FY&F for your next necessary action, and I can confirm the signature for the CEO who was there before me on the 23rd of February while the tender was opening. In other words, Mr. Speaker, sir, this bid bond already had issues even before the tender closed and was opened, and therefore the bid bond was submitted outside the tender document, which is already an irregularity in the procurement. Mr. Speaker, after the cancellation of these tenders, the Global Fund, this issue brought an outcry, and as a result, a principal secretary, the CEO, and officials from the Ministry of Health and KEMSA were suspended as a result. The PS was actually dismissed. Mr. Speaker, sir, an investigation was instituted by the Public Procurement Regulatory Authority, the EACC, both houses of Parliament, both the National Assembly and the Senate, investigation onto the procurement anomalies. Mr. Speaker, one company wrote to us around June 12th or thereabout, asking for return of the bid bond. This company was Shobika, and we were able to, we did not have the document because EACC and other investigating agencies had taken the original documents. And therefore, we wrote back and informed them of the state. And when July came, I think the investigations were happening, officers were recording statements, and that is when I got a call from the Deputy President asking me to surrender the bid bond to Dr. Rigathi Kino. On the same day, because I called EACC, I informed them that, and for the record, Honorable Speaker, I had never received a call from anyone above my cabinet secretary. This was the first time I received a call from a sitting deputy president and requesting for documents that were under investigations. Mr. Speaker, in my 15 years of public service, I had never been asked to do that. And therefore, I felt coerced, and I had to leave the business that I had for the day, go to EACC, follow up the bid bond so that I am able to retrieve it. I was actually able to write a letter to them and follow it up because I had written a letter earlier, and I followed up and sat there for 5 hours for them to discharge the bid bond. And on the same date, I wrote a letter and called for them to collect the bid bond. I think, Mr. Speaker, that explains the conversation and the pressure that I felt as an officer serving in public service. I have explained that the company that had been awarded this tender through the technical evaluation was Shobika Impex, whose local agent, sole agent, is Crystal Limited. Mr. Speaker, sir, I have walked the Senate through the conversation that I had with the question asked by Honorable Dr. Boni Alwale on what transpired and how I was able to get the bid bond. Yes, beyond the financial loss, Mr. Speaker, the nets that we were supposed to buy 14 million nets under KEMSA procurement. As a result of purchasing these nets through the Global Fund WAMBO system, we could only purchase 10.2 million nets. Global Fund could only supply 10.2 million nets. That means Kenyans lost 3 million or so nets as a result. Secondly, there was a delay. We were supposed to implement the distribution of nets to the public from September 2023. That was not possible as a result of the delays. We were only able to start distribution of the nets from January this year. In effect, there was a loss in terms of money, there was a loss in terms of number of nets, and 3, there was a loss in terms of citizens did not enjoy the protection that they would have gotten from the nets in the time that had been envisaged. Indeed, I can confirm, and I've already mentioned, that PS Josephine was dismissed, and acting CEO and other officers were also suspended. About following the law, when I got the call, Honorable Speaker and Senators, I was able to, consult the investigating authorities, and through correspondence, I was able to get the documents as per the law. And therefore, I did not in any way go out of the law as a result. Is the return of bid bond? Mr. Speaker, I'm told my time is up. Can I wind up?
The remaining queries.
Thank you, sir. Mr. Speaker, whether return of bid bond is part of procurement, indeed return of bid bond is not part of the procurement process per se, but after the procurement process, return of bid bond is a usual procedure because people had given commitments in banks, in insurances, and therefore returning bid bonds is a procedure. The extraordinary circumstance in this matter is 1, the bid bond that had been submitted was not part of the tender document per se, and number 2, this was a matter that was under investigation. And therefore, for the Deputy President to push for the bid bond to be returned, it means that it was pushing for interference of an investigation that was already ongoing. I already gave account that I had to personally go to EACC to get the document. Mr. Speaker, I submit. Thank you.
There's some clarifications that are sought from Council Macharia.
Honorable Speaker and honorable members, Honorable Boni Khalwale asked a question from the law. Indeed, there's a hierarchy of laws. It's the Constitution, the laws, and subsidiary legislation. And I cannot purport to be teaching lawmakers how this is done.
5 minutes.
Yes, and so I say this with tremendous respect. The hierarchy of laws, the infrastructure of laws, is that there are provisions left in the Constitution as self-executing. The Constitution then delegates to Senate and the National Assembly the power to make laws to execute certain of its provisions. And to that extent, that statute carries constitutional authority because it is made pursuant to a constitutional provision. And that would be the case with the Political Parties Act. At Article 91 and Article 92, the Constitution prescribes what political parties and the regulation of political parties and coalitions must contain and must do. If a statute is unconstitutional, then the High Court, as it has done many times, then strikes down that statute as unconstitutional. The Political Parties Act, as currently framed, and the basis upon which these coalition agreements were drawn and registered, and a government formed on the basis of those agreements, have not been found to be unconstitutional. So we're not saying that any wrong was done. We're in fact saying everything was done in accordance with the Constitution and the law. That's number one. Number two, when His Excellency the Deputy President stands to make his response before you, amongst the things he'll be showing you in great detail with documentation and with videos is the lengths to which not only he, but his ultimate appointing authority, his boss, the President, and the entire government went to ensure that the development was spread across the country. And I think, as I demonstrated a few minutes ago here, the contracts themselves indicated that there would be need for flexibility to ensure that you are within the Constitution. That did not derogate from the requirement by the parties to implement and to obey and to ensure the contracts were implemented. So they were done constitutionally. And then finally, again, I think I keep emphasizing, they talked about government, they didn't talk about tribes, they didn't talk about regions, and they ensured that the constitutional requirements, as I think Senator Ediwiti had asked me, at Article 91 and 232 were complied with. Thank you very much.
Counsel for the National Assembly. There is a clarification sought by Senator Kavindu. If you may proceed to clarify, then we close and move to the third witness.
Thank you very much, Mr. Speaker. The first question was whether there is any law preventing the Deputy President from intervening when they see any failures in the National Intelligence Service. The answer is that the oath of due execution of the office of the Deputy President, which is in the Constitution, it's part of our Constitution, prohibits the Deputy President from disclosing matters, especially those relating to national security, that are committed to a secrecy. And therefore, it was a violation of his oath of office. It was a violation of the Constitution to discuss matters of that nature at a time in the circumstances prevailing in a press conference broadcast to the whole world. There is a constitutional forum to raise those issues. And indeed, the Deputy President, I want to believe very many other officers, even ordinary citizens can write to that National Security Council if they have genuine grievances about its operations or its personnel or its capabilities and performance. Mr. Speaker, when that oath of office, which is part of our Constitution, says matters committed to the secrecy of the Deputy President are not to be divulged, it is an acknowledgement by our Constitution that there are certain matters which by their very nature, they are not to be broadcast. The Swahili say, usimwage mtama penye kuku wengi. Some things require discretion, they require you be tempered, and they require you know the forum and the occasion to do it. And therefore, it is no answer. Even if we were to accept, for argument's sake, that all the grievances the Deputy President had are factually correct, it will still be no answer to that charge. The second question was whether Justice Maina has made any complaint after the case was done. We are not aware of any complaint lodged by the Honorable Lady Justice Maina. But that question, Mr. Speaker, also tells you why this is an impeachable offense. Those who know our constitutional theory say judges hold neither sword nor the purse. The reason our constitution protects judges and puts them in a special place is because, unlike politicians and the executive, they have no way and no forum of dealing with harassment from the political branches of government. But if we are wrong in that, Mr. Speaker, again, why I'm very happy with this question, you imagine, let's accept for argument's sake that indeed Justice Maina could have lodged a complaint, because it's possible she would have walked to a police station, met an OCS there, recorded a complaint and a statement. Dr. Mula has just been here as a junior officer. The practicalities of an OCS, a police constable, summoning the Deputy President of the Republic to respond to a complaint, the whole specter of handcuffing, taking fingerprints, processing the Deputy President to take him to the magistrate's court to answer to a criminal offense, would subject that office to so much indignity. And because the design of our constitution is that people holding certain offices, in fact, the constitutional text is that they should behave in a manner that brings honor and dignity to the office. It is to save the country the drama, the spectacle of a junior police officer, a junior prosecutor, harassing, arresting, prosecuting a deputy, and because we don't want to subject our democracy to this kind of showbiz. That is why this Senate is vested with the power of impeachment, and that is why our Supreme Court has said several times, as I pointed out yesterday, the test is not whether he is criminally liable or civilly liable, which is the business of the judiciary. I so submit, Mr. Speaker.
Now, Counsel for the National Assembly, you may call your third witness.
Honorable Speaker, distinguished senators, my name is Moses Kipkogei. Our next witness is Abdi Mahmoud from the EACC. He's a former witness who was called pursuant to the summons issued by this House at the request of the National Assembly. I request the Sergeant at Arms to call him from room 4. Sorry.
Mr. Speaker, may I just raise a concern? It is true that this witness was called pursuant to a summons of the Senate, but normally a witness is called to produce a particular document or to produce a particular item. As we stand now, none of us knows what this witness is coming to produce, so we can't even pull it out from these massive documents. We want it to go on record that this is trial by ambush. We will know for the first time what this witness has come here to do when he begins speaking. I just want that to go on record, but before he starts, I want counsel to tell us what documents this witness wants to rely on, so that against all the unfairness we have witnessed, at least we can have some semblance of looking at it. Thank you, Mr. Speaker.
Counsel for the National Assembly, what say you?
Mr. Speaker, the documents to be identified by the witness are contained in Volume 8A of our bundle.
Call in the witness, please. Just have the witness on this side.
Okay.
Where the others took the oath. Now, just to remind counsel for the National Assembly, you have 20 minutes to conclude on your case, and the counsel for the Deputy President, you still have your 45 minutes intact for purposes of cross-examination. Let's proceed.
Thank you, Mr. Speaker. I intend to use 15 minutes to take the witness in chief and reserve 5 minutes for any re-exam.
So before the witness takes an oath, counsel for the Deputy President, you do confirm now that you understand and you know the documents that the witness is going to produce as contained in volume 8A. And these are the documents, I believe, in respect to which I made a ruling yesterday, to have them admitted.
We do, Mheshimiwa Speaker.
Thank you so much, Senior Counsel.
Yeah, thank you.
Thank you. So this is, we cannot, and as a chair, I cannot allow trial by ambush. Proceed.
Thank you. I, Abdi Ahmed Mohamud, do solemnly swear that the evidence that I shall give before this Senate in respect of the matters before the Senate shall be the truth, the whole truth, and nothing but the truth, so help me God. Thank you.
So, Mr. Abdi, introduce yourself to the Senate, the place you work, your rank, and how many years you worked in that institution.
Thank you. My name is Abdi Mohamud. I'm the Deputy Chief Executive Officer of the Ethics and Anti-Corruption Commission. I have worked at the Commission since 2005. I started off as a senior investigator. Right now, I'm the Deputy Chief Executive Officer. My main responsibilities are to assist the Chief Executive Officer of the Commission in the day-to-day running of the Commission, among others. Another key role and responsibility that I hold at the Commission is that I chair the Commission Management Committee on Investigation Evaluation. Basically, I have been an investigator since 2005 when I joined the Commission. Thank you.
Thank you, Mr. Mahmoud. You are before the Senate this morning following summonses which were issued to your institution. And in the summonses, the 3 areas were identified. Would you wish to appraise the Senate on those 3 areas which you are to guide the Senate on?
Okay. If I may refer to my documents,
yes, you can.
Thank you. So there are 3 areas that I was requested to comment on. The first one is an investigation that the Commission conducted on a procurement on the supply of long-lasting insecticide nets at the Kenya Medical Supplies Agency, KEMSA. The second issue that I was to comment on is the declaration of gifts and donations received by His Excellency Rigathi Gachagua, the Deputy President, during his tenure of the office to date, pursuant to Section 14(5) of the Leadership and Integrity Act. The third issue that I was to comment on is the declaration of conflict of interest made to the Ethics and Anti-Corruption Commission by His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, to date.
So we'll go to the first question, or the first issue, which you are asked to address yourself to. And I wish to refer the witness, Honorable Speaker, to our bundle 8 of our documents. Can you identify the document at page 3 of that document?
Yes, I can identify. This is a letter that we did to the Clerk of the National Assembly on 23rd September 2024. It was responding to a letter that we received from the National Assembly requesting us to furnish the National Assembly with information on the investigation that we conducted on the long-lasting insecticide nets, and to indicate in our responses any outcome or status of the investigation that we did conduct.
So your letter in that volume relates to procurement of certain items at KEMSA, am I correct?
You are correct.
You've appraised the Senate, the National Assembly in that letter. Would you appraise the Senate on its contents?
The content is the procurement of long-lasting insecticides by KEMSA. This was in the year 2023, and the Commission, in its functions, either it conducts investigation on its own motion or at the instigation of other parties. For this particular investigation, we did receive a letter from the CS, who was then in charge of the Ministry of Health, indicating that there were certain irregularities in a procurement of insecticide nets by the KEMSA, and the CS then wanted us to conduct investigation and find out whether certain procurement irregularities did take place. And from that, we actually did carry out investigation, and the outcome of the investigation so far is already reflected in the letter that we have provided.
And what was the outcome of the investigations, Mr. Mahmoud?
There were serious procurement challenges that affected that particular tender. The major one was change of specifications to suit a company called Shobika Impex Limited, which was having which had a local agent by the name Crystal Kenya Limited that had the sole responsibility, or rather the sole function, to provide certain mosquitoes that had certain chemicals. So basically what the investigation concluded is that there are two types of chemicals that were used on these particular nets. If I may read one of them, one is called Synergist piperolene butoxide, PBO, long-lasting insecticides nets, while the other one is pyrethroid, long-lasting insecticide nets. So this company had the sole distribution rights on this particular chemical called PPO. And in totality, from the investigation, we realized that the PS at that particular time did write to the CEO of KEMSA, instigating or rather compelling the CEO of KEMSA to change the specifications so that it can fit the chemical that was to be provided by Shobika Impex Limited, whose local agent was Crystal Kenya Limited. Basically, that was the starting point. The other problem was that there was, when the tender was to close on 23rd, the company, this is Shobika Impex Limited, at that particular time wanted to have a bid bond introduced into the documents, into the tender documents. Yet we all know that in procurement, the tender document, the bid bond is supposed to be part of the tender document. They're supposed to be delivered together. But in this circumstance, the bid bond was delivered by hand to the CEO's office on 23rd when the tender was supposed to close. So they had to find a way of extending the period of closure up to 10th of the next month of March, so that that particular bid bond, which had issues, can now be factored in, or rather regularized, and so that this company called Shobika could benefit out of that particular extension. Of course, there are many other issues. Like, we also realized that at the end of the, when the tender was discontinued, for example, there is a company called Tianjin Yorkol International Trading Company that was among the bidders that initially bidded for this particular tender. They were disqualified on a fact that they were not authorized by a manufacturer. This company had provided sufficient evidence and proof that they're actually manufacturers. So a company that is a manufacturer was disqualified on the ground that they did not provide authorization from a manufacturer, yet they are actually manufacturers. So those are some of the challenges that the tender had. And
at the end of it all, what became of this tender?
At the end of what happened is, after the technical committee of the KEMSA did recommend Shobika to be awarded the tender, because this tender was actually was being financed by Global Fund. So the agreement was, after the tender evaluation committee's report is done, that report is to be handed over to Global Fund, the financiers. So when that report was surrendered or handed over to the Global Fund realized...
You said the evaluation committee of KEMSA,
yes,
made a recommendation that Shobika be
awarded. That was the finding. That was the
finding of KEMSA.
That was the recommendation by the technical committee.
What happened next?
What happened is Global Fund decided to terminate the tender and asked an internal firm, or rather an internal organization called Wombo.org, which is the procuring arm of Global Fund, to do the procurement. And eventually, one of the companies that were actually disqualified because they were not authorized by a manufacturer ended up winning that tender, together with another firm called A to Z Textile Mills Limited. So those were the eventual winners, but that was after the termination of the recommendation by the technical committee of KEMSA.
So, just to clarify to the Senate, a company which had been disqualified by KEMSA ended up being the supplier.
That is correct.
Following the process which was undertaken by Global Bank.
That is correct.
Okay. What became of the bid bond?
Well, when we were investigating this, when the investigation was ongoing, we collected all the bid bonds of the firms that actually bidded, so that not only the bid bonds, but all the documents that related to the tender, so that we could evaluate and record statements. Now, the one that had issues was this one for Shobika. But when the tender was terminated, ordinarily, there would be no need to hold onto tenders or onto documents submitted by the tenderers, and they're usually returned. But for this particular one, because it was a questioned document, the CEO of KEMSA wrote to the EACC requesting for that document to be handed over. And eventually we did hand over the document to him after recommending disciplinary action against all the officers who were involved in the tendering process, starting with the CEO, the technical committee members, the head of procurement entity. For this particular document, we have a certified copy, which we collected in case there would be need to reopen the investigation, because there could have been other offenses that could come out of the investigation.
Did you hand over the bid bonds for the other companies which had participated in this?
They were returned to KEMSA.
They were returned to KEMSA. Let's go to the second issue, which was identified in your invite, and probably we should start with the third one, which relates to conflict of interest by state officers and public officers. You are a long-serving officer of the Ethics and Anti-Corruption Commission. I suppose you are familiar with conflict of interest in terms of the constitutional, statutory, and regulatory procedures. Would you appraise the Senate on that aspect?
Okay, thank you. So conflict of interest is actually addressed under Section 16 of the Leadership and Integrity Act, and it clearly states that a state officer or a public officer shall use the best efforts to avoid being in a situation where personal interests conflict or appear to conflict with the state officers or public officers' official duties. Now, when we talk of personal interest, we look at Section 6, which explains or rather indicates that personal interest includes interest of spouse, child, business associates, agents, or any other matter in which the state officer or public officer has a direct or indirect pecuniary interest. Basically, in practice, what happens is we also have the regulation, which is the subsidiary law of that particular act. If we look at the conflict of interest, that particular part 3 of the leadership and integrity regulations clearly specifies how conflict of interest are supposed to be dealt with by public officers.
And in summary, how are state officers to deal with questions of conflict?
All public institutions are actually required to maintain a conflict of interest registers, which can be inspected by individuals upon application. That is the starting point. If, for example, a public officer or a state officer feels that he is conflicted, he is supposed to declare the conflict in that particular register. And you know, the commission also has a role in that the commission is actually mandated to enforce and implement the Leadership and Integrity Act together with the regulations.
Thank you, Mr. Mahmood. And did you say, did I hear you correctly say, that conflict of interest extends to children, spouses, and business associates? Did I hear you correctly?
That is correct. That is subsection 6, section 16.
Let's go to the third issue in view of time, which is in relation to gifts.
Okay, gifts. If you look at section 14 of the Leadership and Integrity Act, together with section 5 of the regulations of the same act, it is clearly indicated that gifts received by a public officer is a donation to the state. That is what Regulation 5 indicates. If you go down there, you will also see that a state officer or public officer who receives a gift whose value exceeds 20,000 Kenya shillings shall, within 48 hours of reporting to the office, surrender it to the public entity in which the officer is employed. It also goes further in subsection 4 to indicate that a state officer or a public officer who receives a gift in terms of this regulation shall, irrespective of the monetary value of the gift, declare the gift received to public entity which the public officer represents. Finally,
all gifts are supposed to be declared, regardless of its monetary value.
Yeah, maybe, yes, that is correct. But what I maybe should have mentioned is that public officers and state officers are barred to receive any monetary gift. So here we are dealing with gifts that are not non-monetary. For monetary, they are barred, or rather we are barred from receiving any monetary gift. But yeah, so this.
And in the same manner, with respect to conflict of interest, we have a register of conflict of interest. Do we have a register of gifts?
Yes, we have a register of benefits in each and every public agency where officers who receive gifts are supposed to declare immediately, and we have indicated in 48 hours. And what I would also wish to mention is that
what is the role of the Commission in relation to gifts?
Okay. Yeah, now if you look at subsection 9 of the regulations, you will see that if a public entity shall, at the close of every financial year, furnish the Commission with a report specifying, and you know, all the gifts, any gift the entity intends to dispose of, all that. And then subsection 3, of course, talks about report. The report under paragraph 1 shall be submitted to the Commission within 30 days after the close of the financial year.
So just so that we can close on that, every financial year, the Commission is supposed to receive the registers of gifts from all state entities.
That is correct.
For your record.
Yeah.
Have you received the register of gifts from the Office of the Deputy President?
Not to my knowledge.
Not to your knowledge. That will be all, Mr. Speaker.
Can I, through Mheshimiwa Speaker, ask whether the National Assembly still wishes to call a witness whose affidavit was filed, the governor of the county government of Nairobi, Johnson Sakaja. We have a copy of his affidavit. Is he going to be called or not called? Because if the National Assembly is not calling that affidavit, whose affidavit is part of the record and was availed to us, that affidavit, Mheshimiwa Speaker, contains allegations that are extremely injurious to the Deputy President. So if he is not going to be called, we will be making an application for that affidavit to be expunged from the records of this Honorable Senate. Thank you.
Counsel for the National Assembly, you had listed quite a number of witnesses. Are you going to call all of them, or are you going to, for the record, are you going to close your case where we are?
Mr. Speaker, sir, on behalf of the National Assembly, we shall close our case where we are. Mr. Speaker, sir, if you are, with your permission, I could respond to the submissions by my learned senior, Mr. Paul Mwite.
Please do.
Mr. Speaker, sir, at the beginning of the proceedings that we are currently going through, this House did invite parties to give indications as to the witnesses they wanted to call. Mr. Speaker, sir, we gave the list of the witnesses whom we thought were relevant for purposes of clarifying what we needed to have clarified. If counsel for His Excellency the Deputy President did not do as much or did not take advantage of that window that was open, surely they cannot blame us for it. But secondly, and more importantly, Mr. Speaker, sir, yesterday, in the course of the deliberations in relation to one of the preliminary questions that had been raised, you gave a very clear ruling on the intendment of Rule 20 of the rules of this House. In particular, the understanding was that every material that was forwarded by the Speaker of the National Assembly to this House constituted evidence in support of the allegations that are the subject of inquiry by this House. It then follows that if the application that learned senior counsel, Mr. Paul Mwite, is making were to be looked at in its totality, he is actually making an application to amend or to remove certain aspects of the evidence from the record. Mr. Speaker, sir, that is an issue that you settled and rested yesterday. I don't think it's an issue that is open for re-intervention. Mr. Speaker, sir, it should also suffice to note that even on our side, there are affidavits that form part of the record that came from the National Assembly. In particular, there is an affidavit sworn and which is in favor of His Excellency the Deputy President, an affidavit sworn by the joint executors of the will, that is Mr. Njoroge Rigeru, together with the other executors. It is part of this record. We have not made an application to have it expunged. We have an opportunity to deal with it when the time comes. Lastly, Mr. Speaker, sir, the nature of the sittings that this House currently is undertaking is quasi-judicial. It is inquisitorial in nature. If that is to be the correct position, Mr. Speaker, sir, then the rules of evidence as we know it in the court would not necessarily bind the proceedings, because what has been presented is the subject of what the honorable senators are going to investigate. At the end of it, it is not a judgment that they will be giving, it will be a vote. I rest my case, Mr. Speaker, sir.
Senior Counsel Paul Mwite.
Mheshimiwa Speaker, first and foremost, the affidavits that my colleague, my learned friend, referred to were sworn by the executors of the will of the late brother to the Deputy President. They were filed in the National Assembly, in the proceedings in the National Assemblies. They were never filed here as affidavits of witnesses that we proposed to call. With regard to the affidavit of Governor Sakaja Johnston, it was specifically filed in the Senate, an affidavit of a witness that they intended to call. That affidavit has material injurious to the Deputy President. Mheshimiwa Speaker, we were looking forward to cross-examining Governor Sakaja so as to bring out the truth to assist this Honorable Senate to make a decision. If he is not being called, and in fairness to the deputy governor, all that we are asking is that affidavit be expunged together with the affidavit of Peterson Jomo, who they are not calling now, and also the affidavit of Mercy Wajau, who is not being called. It is not fair to file affidavits containing information allegations injurious to the other party, then ask that those affidavits to remain as part of the record without calling them and availing them for cross-examination. So my application is that the 3 affidavits be struck out. Thank you.
Mr. Speaker, sir, just for clarity, there's absolutely no new material that was presented after the material that was sent to this House from the National Assembly. For instance, the affidavit by His Excellency Johnson Sakaja is to be found at volume 1 of the documents that have been filed.
Maybe counsel for the National Assembly. Let me get it clear.
Yes,
the
Mr.
affidavit by the Nairobi governor, was it filed after the proceedings of the National Assembly, or it forms part and parcel of the proceedings that came from the National Assembly?
It forms part and parcel of the proceedings that came from the National Assembly. In particular, Mr. Speaker, sir, all those affidavits form what constituted part of what came into through public participation.
So just holding that so that we make progress. Senior counsel, you have indicated that the affidavit by the Honorable Governor for Nairobi did not form part of the documents that emanated from the National Assembly. Now, the position as held by the Council of the National Assembly is to the contrary. These are things we can settle now. Did it come with a bundle of documents from the National Assembly, or it was filed after the Senate was seized of those documents?
Mheshimiwa Speaker, I have been corrected by my colleagues. The affidavits where the affidavit by Governor Johnson Sakaja was actually part of the public participation. So it was part of the record of the National
So now,
yes,
let's move to the 2.
Yes.
Let's move to the 2. Now, have a seat, Senior Counsel. Counsel for the National Assembly.
Yes, Mr. Speaker, sir.
Yeah, respond to the 2 more affidavits, because the contention from the Council of the Deputy President is that they were filed after the record was received from the National Assembly by the Senate.
Mr. Speaker, sir, I reiterate the position that we earlier on gave, that there's not any single document other than the document that was admitted yesterday pursuant to our application that came in after the record had been presented before this House.
So the affidavits were not filed after the Senate received the bundle of documents from the National Assembly?
Absolutely not.
Can you lead us to the volume and the page containing these affidavits from the National Assembly?
Mr. Speaker, sir, just give me 1 minute to consult with my colleagues here. I identify it, then I bring it. It's not an issue that we had anticipated.
Yeah, so that we settle this matter.
Most of that.
Yeah, let's settle it.
It is not, Mheshimiwa Speaker, it's only the affidavit of Peterson Jomo that was filed in the Senate. It did not form any part
Very well,
of the
Senior
National
Counsel.
Assembly.
So then let's settle that one and we make progress. We need not argue on this matter.
Mr. Speaker, sir, I think what happened is that we skipped the opportunity to identify the documents from both sides of what had been filed. The documents that we filed yesterday has a volume 8. That is the document that contains the affidavit of Peterson Jomo.
So it is that affidavit, if you go to the Senior Counsel, it is that affidavit that they're looking forward to cross-examining the deponent. Now that you've closed your case, the argument from the counsel of the Deputy President is, how then are we going to test the truth of those averments? What say you on that?
Mr. Speaker, sir, I did give an indication that, number one, at the commencement of these proceedings, any party who wanted to cross-examine any of the deponents of any of the documents had an opportunity, upon your invitation, to invite such parties to appear before them. If our counterparts appearing for His Excellency the Deputy President did not find it appropriate to call that witness at that point in time, they cannot now hold us to say that you had said you'd call this person, you will not call them. Because the person we were to call was for purposes of clarifying what we thought was important for us. Now, this being an inquisitorial proceeding, a quasi-judicial proceeding, Mr. Speaker, sir, I think it would be a stretch to expect that if we didn't call or if we didn't avail any of the witnesses that were mentioned in any of the affidavits, then as of necessity that follows that that record or that affidavit needs to be expunged. That's what I was saying. Pursuant to your ruling yesterday, that is evidence and material that was presented yesterday. It forms part of your record.
Now, before I give my way forward, Senator for Nairobi City.
Honorable Speaker, the counsel that are appearing in this case are people that I hold in extremely high regard. Senior Counsel Paul Muite appears to not have the confidence of the judges sitting here that we know how to treat evidence contained in an affidavit that is not tested at cross-examination. Even the judges you appear before in the courts that you practice in know what to do with evidence of a person who is not availing themselves for cross-examination. So, Honorable Speaker, I really don't understand what the contention is, because we sitting here as judges know how to treat that evidence, and I wanted to take this opportunity to calm the anxiety of Senior Counsel Paul Muite, that indeed we do know what to do with such evidence.
Now, so that we make progress, Senior Counsel has raised an important matter, which matter has been responded to by the Counsel for the National Assembly. Now, honorable senators, there is an affidavit sworn by one Jomo Mushira, who had been listed to appear as a witness for and on behalf of the National Assembly. The National Assembly has closed its case without calling that particular witness, and yet there's an affidavit that the counsel for the Deputy President will not have an opportunity to cross-examine. The question, as you retire at the end of this hearing, is to look at the probative value of that particular document. Senior Counsel Paul Muite, your point is valid. The senators have noted.
Because this is an important, very important institution with a judicial function, court of record, permit me to put on record that there is a slight distinction between counsel and the client. I have absolute full faith in honorable senators, including my friend, the senator for Nairobi, but I am carrying out instructions of my client.
Yeah, so I've given direction on this particular matter. Let us move forward. Having said that, Senior Counsel Paul Muite, if you're ready, you may now usher in your witness.
Mheshimiwa Speaker, we are anxiously waiting for the Deputy President. My colleagues can stand here, can stand in. For me, let me make inquiries and find out where he's held up. We certainly wish to call him as a witness.
Very well. Yes, what is your point of procedure, Senator Boni?
Unprecedented, to the extent that when we stand down business in this House, it normally arises from a communication from the chair that you're temporarily, for a specific time, suspending the proceedings. You have not done this, and we are seated in the chamber. The mess is in place. I do not know whether we want this to be the new standard, Mr. Speaker. Could you guide us? We have no idea how long we're going to wait. And time is running, Mr. Speaker.
Honorable Senators, at the rise of the House at 1:15, I made it clear that upon resumption, the Deputy President was going to take the stand. We came in here, I communicated the program for the afternoon, and I said we're going to execute it with military precision, owing to the fact that we need to conclude business today. Senior Counsel Paul Mwite indicated that he cannot get hold of his client. That is not the concern of this House. So time is running. Order, order, honorable senators, order. The floor is available to the Deputy President and no other senator or no other element.
Well, the Speaker of the Senate, Honorable Amason Kingi, currently presiding over the business of the Senate this afternoon, has just directed that the floor at this particular juncture is not available to any other senator owing to the...
Enoch, I used very basic English. I know you. You have such a wonderful grasp of the language. You need not to get any clarification.
It is exactly 15:04 p.m. this afternoon, being the 17th day of October 2024. The afternoon sitting of the Senate this afternoon was to kick off with the Deputy President taking the stand, bearing in mind the DP, His Excellency Rigathi Gachagua, is the sole witness in the case where the National Assembly, through the move of the motion, Honorable Mwengi Mutuse has leveled 11 grounds for impeachment of the Deputy President from office. We have already dispensed with the prosecution side, and during this afternoon sitting, immediately after the commencement of business, the council representing the National Assembly have confirmed to the House that they do not intend to call more witness in regards to this case. The counsel for the Deputy President had requested the House through the Speaker that any evidence where the witnesses are not appearing be expunged from the record. It is a moment of waiting at the Senate this afternoon as the House awaits the arrival of the Deputy President, Rigathi Gachagua, who is set to take this stand at the Senate this afternoon and prosecute his case through himself as well as his defense and convince senators why the 11 grounds listed for impeachment should be quashed by the House. Our dear viewers, the motion for the removal by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya, has 11 grounds where the National Assembly is seeking to have the Senate uphold the charges, or at least one of them, to have the Deputy President cease to hold office today. The mover of this motion, Honorable Mwengi Mutuse, who also serves as Kibwezi West lawmaker, has told senators for the better part of yesterday and today that his desire through this motion is that the House finds the Deputy President to have committed the offenses listed in this motion. And this afternoon, the defense of the Deputy President, led by Senior Counsel Lawyer Paul Muite, will be seeking to water down those charges by the evidence that they will be presenting before the Senate this afternoon. And to just take you through probably some of the charges that the Deputy President will be seeking to counter this afternoon is charge number 1 on the gross violation of the Constitution and any other law. This is pursuant to Articles 150, subsection 1BI of the Constitution. Charge number 2 in the impeachment motion by Honorable Member for Kibwezi West. The Honorable Member alleges in his motion that there is gross violation of Articles 147 subsection 1 and 152 subsection 1 of the Constitution, where the Deputy President is being accused of undermining the presidency. Under Article 147 subsection 1 of the Constitution, the Deputy President is the principal assistant of the President and shall deputize the President in the execution of President's function. In this motion, the Honorable Deputy President is accused of going in contravention with cabinet resolutions on matters evacuation of people residing along Nairobi River, and that shortly after His Excellency, shortly after being in contravention with the cabinet resolution, the Deputy President made public a statement opposing the Nairobi River riparian execution orders. According to the mover of the motion, this is undermining the resolutions by the cabinet. Under charge number 3, again on gross violation of Article 6, subsection 2, Articles 10, subsection 2A, Article 174, and Article 188, and the 4th schedule of the Constitution, where the Deputy President is accused of undermining devolution. The mover of the motion in his motion states that on the 28th of September 2024, His Excellency Rigathi Gachagua, recklessly and mindful of the high calling and dignified status of the office of the Deputy President, unlawfully interfered with the running of the Nairobi County government by holding a public rally in which he incited citizens against lawful directives by the Nairobi City County government on the planning and relocation of markets. This is just some of the grounds listed or some of the annexes under charge number 3, where the Deputy President is set to defend himself on these charges, among others.
Senior Counsel Paul Mwita, your time started running.
Mheshimiwa Speaker, may I...
Let me just conclude, Senior. Your time started running at the time I requested you to usher in your witness. You indicated that you're getting hold of your witness. We'll give you all the time you need to get hold of your witness, but to let you know that the clock is running, and it's running on your client. You can take all the time, but his time is running out. After 2 hours, he's not appeared, the chair will make a ruling pursuant to the rules of procedure.
Mheshimiwa Speaker, may I start first and foremost by expressing apologies and regrets that the Deputy President is not here, and by not being here, the inconvenience and delay caused to Mheshimiwa Speaker and to honorable senators. The position, Mheshimiwa Speaker, is that during that period that I went to try to find out why he wasn't here, because as Mheshimiwa Speaker knows, the Deputy President has been coming here absolutely punctually every day. The sad reality is that the Deputy President, the Republic of Kenya, has been taken sick, very sick, and as I address Mr. Speaker in this honorable House, senators, he is in hospital, Mheshimiwa Speaker. That is a sad reality.
Order, honorable senators. Order, honorable senators. Senator Kajwang. Now, Counsel for the National Assembly, you have had Senior Counsel Paul Mwita for and on behalf of the Deputy President. Considering that this is a time-bound process, what is your reaction?
Mr. Speaker, sir, this is a house governed by the rule of law. We truly empathize with the difficulty that His Excellency, the Deputy President, has found himself in. But, Mr. Speaker, sir, pursuant to Rule 11 of the rules governing this process, if I may, with your permission,
maybe Counsel for the National Assembly.
Yes, Mr. Speaker, sir.
Just take a seat before you make your rejoinder. Senior Counsel Paul Muite, having said whatever you've said, what is your proposed way forward so that a reaction can be put from the National Assembly? Are you telling us we wait until your client gets here? What is your proposed way forward?
Mheshimiwa Speaker, I have just received this information. My proposal is that you give me at least the rest of the day. I would like to go and have an assessment of his situation and maybe even come back here by 5 p.m. Right now, I would like to make an informed sort of situation after I see the Deputy President and I see the doctor, Mheshimiwa Speaker, at least an hour or two. Yes, thank you.
Very well. Counsel for the National Assembly.
Mr. Speaker, sir, having very keenly listened to my learned senior colleague, Paul Muite, Senior Counsel, it puts us in a bit of a difficulty because whereas we may want to empathize with the situation, there appears to be no indication from their end as to a specific proposal. Mr. Speaker, sir, this being a house governed by rules and this process being a time-bound process, I will draw your attention to Rule 11 of the rules of this House. If I may read, Mr. Speaker, sir, that where the National Assembly or the President chooses not to appear before the Senate, that fact shall be put on record and the Senate shall proceed with its investigation without further reference to the National Assembly or the President. But the Senate may, for exceptional reasons to be recorded, permit a later appearance before the Senate by the National Assembly or the President. Mr. Speaker, sir, I think this rule would give us guidance we may proceed. If it becomes necessary, then any additional material may then be availed. This is a time-bound constitutional process, Mr. Speaker, sir. I'm most obliged.
Let me pick the wisdom of my wonderful senators before I make my decision on the way forward. Now, I understand that all of you are wise men and women.
Speaker, can I just say a word?
Yes.
I've heard what Senior Counsel Paul Muite has said. And, Mr. Speaker, you have made it quite clear that these proceedings are time-bound. It's not so much about the situation in which His Excellency the Vice President finds himself. It's about the Senate complying with the provisions of the Constitution. That within that time frame, you must make a decision. Reading the standing orders that my learned friend, Mr. Rick Gumbo, has referred to, it would be useful to this House if Senior Counsel Paul Muite could probably give us a way forward in terms of the time limitations that the Senate has. I'm saying this because we don't want somebody to say that the Deputy President was not given an opportunity to be heard. I think the Senate will want him to be heard. But knowing the time limitation, what suggestions does the Senior Counsel have to ensure that we keep within the time parameters? At the same time, the Deputy President is given his space to defend himself.
So we have two sides. We have the minority side and the majority side. I will only allow the two leaders to speak. If you need to consult in the next 1 minute, now, honorable senators, our standing orders have not been suspended yet. It is only Senator Mazayo and the majority leader. The rest, take your seat. The rest, please take your seat. Order, honorable senators.
Mwengi Mutuse, who is the mover of this motion, as well as the former KEMSA CEO, Dr. Andrew Mula. And immediately after that, the House proceeded for a lunch break, and we are resuming this afternoon to commence the second part of this hearing, where the Deputy President will be accorded a maximum of 2 hours for evidence of witnesses and re-examination. The National Assembly will then have a maximum of 2 hours for cross-examination. That will happen during this afternoon session, where the Deputy President will be telling senators why the 11 charges leveled against him, among the charges being undermining matters to do with devolution, undermining the presidency, and matters to do with gross misconduct, why the charges are frivolous and baseless, as has been termed by his counsel. After the completion of the allocated time, which is about 4 hours according to the program, during this afternoon session, the House will then move to have senators ask questions as well as clarifications. And thereafter, the National Assembly will be given an hour to do their closing statements. Our dear viewers, here is where the Defense Counsel for the prosecution here being the National Assembly, the team at the National Assembly, they are being led by lawyers, Honorable James Orengo being the lead counsel of the team, as well as lawyers such as Muthomi Thiankolu. And during the 60 minutes allocated by the Speaker, being the closing statement, the National Assembly will be having their final opportunity to convince the House why they should uphold the impeachment charges leveled against the Deputy President. Similarly, the Defense Counsel and the Deputy President of the Republic of Kenya will equally be accorded 60 minutes to convince senators, this being last-minute attempts to convince the House why the charges against the Deputy President should not be upheld, and why the Deputy President of the Republic of Kenya ought to continue being in office. After the completion of the closing statements by the two sides, we will be having a closed-door session by senators before the honorable members of the Senate consider and vote on the 11 grounds for removal from office. The Speaker of the Senate, Honorable Amason Jeffa Kingi, has already stepped into the chamber this afternoon. Allow me to hand you over for this live broadcast brought to you by the Parliamentary Broadcasting Unit in partnership with KBC. My name is Gladys Mungai. Enjoy your viewing.
Na tuombe. Ewe Mwenyezi Mungu, twakusihi tutazame kwa